Welcome back to Lost Dash Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. In this video, we're going to revisit once again California knife laws, which are somewhat complicated because they have to cover a bunch of different weapons, anywhere from the pocket knife, such as this one, or kitchen knife, or the classic Dirk and Dagger, like the one that I have in my hand, an ice pick made by the Central California Ice Company. And then we're going to focus on the case where an individual claims that there was insufficiency of evidence for the jury to find that his knife fit within the definition of Dirk and Dagger. One day I'll make a video showing you my collection of knives. And I will tell you that ice picks are my favorite. I have a few of them. They're a good tool to use when you're eating blueberries or if you're trying to get that steak off the grill. But until then, let's focus on the case of People versus Belloso, which is a Court of Appeals case from the state of California. And here's what happened. In 2018, two deputy sheriffs were driving in an unmarked vehicle. They saw Mr. Belloso walking in the same direction as the car, but he was walking very rigid. He was looking around. He looked nervous. He kept looking back and forth. And so the officers decided to pull alongside Mr. Belloso. At that point, Mr. Belloso took a large knife out of his pocket and held it next to him. Now, the officers walked out of the car, and at that point, Mr. Belloso dropped the knife on the ground, got on his knees, and was detained. Now, he was later charged with carrying a concealed Dirk and Dagger. Here's what the knife looked like. This was a 9-inch knife that was rigid. You could not fold it, so it's not like a pocket knife. The blade was about 4.5 inches. It was straight on one edge and curved on the other, and there was a pointed tip at the end. Now, Mr. Belloso told the officers that he was not from the area and he was quote-unquote sketched out. So he was carrying this knife for protection. Now, after the trial, he was convicted of carrying the knife, carrying this Dirk and Dagger concealed. Remember, there are two different laws. We're focusing here on carrying a concealed Dirk and Dagger, meaning that it's not visible to people from outside. It was hidden in his pocket. Now, we know that under section 21.310, it is a criminal offense to carry a concealed Dirk and Dagger upon a person. Now, section 16.470 defines a Dirk and Dagger as a knife or other instrument with or without a handguard that is capable of ready use as a stabbing weapon that may inflict great bodily injury or death. Now, the question whether something is a Dirk and Dagger is a question of fact, meaning that the jury has to decide. And in this case, the jury made the decision that the knife was in fact Dirk and Dagger. Mr. Belloso appeals. He says that there was insufficient evidence for the conclusion that this was in fact a Dirk and Dagger. He tells the Court of Appeals that the deputy who testified in court did not testify as to some of the characteristics of the knife. He testified that this was a knife that was 4 inches fixed blade and it was wrapped in paper to prevent it from cutting someone, meaning when they were passing around this knife, it was covered with paper and a rubber band. This way people, namely the jury, would not cut themselves. But he never testified whether the knife was sharp or dull, or whether it was pointed or rounded edge, or whether it had a fixed blade that was rigid or flexible. Because of that, Mr. Belloso says that there was insufficient evidence that this was in fact a Dirk and Dagger. But the Court of Appeals disagrees. They say that the jury was able to observe the weapon, the photos of the knife were later admitted into evidence, so they could see it again, presumably in the jury deliberation. And then at the end of the day, we also have the statement by Mr. Bioso. He said that he was out of the area. So the Court of Appeal says it wouldn't make much sense for somebody to be carrying a dull knife that you're not willing to use as protection when you're testifying and telling the officers that you are in fact carrying the weapon concealed for protection. So at the end of the day, the Court of Appeals says this was in fact a Dirk and Dagger, and they uphold the jury's conclusion. Now, they also provide a number of other cases that I might give you later on. I might make more videos dealing with these cases. We have a case that a 3.5-inch blade that's rigid, sharpened on both sides, and has a sharp point was in fact a Dirk and Dagger. A steak knife with 4.5/8-inch blade was also Dirk and Dagger. A kitchen knife with an 8-inch blade, one cutting edge, and a point was in fact a Dirk and Dagger. But finally, a bread knife was not a Dirk and Dagger. So a regular kitchen knife that you're using, like a steak knife, would in fact be a Dirk and Dagger. But a bread knife, as described in this other case, was not a Dirk and Dagger. If you understand a little bit more about California concealed knife laws, please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. Thanks for watching.